So I'm actually doing two talks today, this one and then another one this afternoon, that draw on the same work, which is a project I've been conducting with this attractive gentleman here. Yes, and his name is Dr. Darren Sinclair. And so we've been working with probably what you would call the main regulator in the Murray-Darling Basin at a state level at least. And they're known as the New South Wales Office of Water, or DPI Water. And for the last 3 years, we've been looking at how they regulate markets, how they regulate drillers, and how they regulate something called controlled activities, which is kind of what you do along streams. And so what I'm going to talk about here is regulating bore drillers particularly, and then later on I'll talk about regulating groundwater markets this afternoon. So just a bit of an outline. I'll just kind of explain why we came to focus on drillers and why regulating them is particularly important when you think about the nexus between groundwater and agriculture. Then a little bit about kind of the regulatory challenge they pose for governments before talking a bit about compliance and enforcement and the findings that we got from our project about how effective governments are in regulating drillers in particular. And that kind of leads me to argue that we need to be looking for more flexible regulatory solutions rather than state-controlled approaches. Hopefully, what I have to say will have some relevance to other contexts, particularly California, but you might have to probe me to find out about that in the questions. So why is drilling important? Probably, at least from the social science side of things, we spend a lot of time focusing on kind of what we do with the water once we've got it out of the ground and whether it's sustainable. But drillers actually play kind of a gatekeeper role or a linchpin role in the sense that you can't get access to water unless a driller comes along and puts a bore down for you. And in that sense, how they drill that bore, so do they do it safely? Do they do it so that we're not piercing multiple aquifers and causing leakage between different layers? Do they do it in a way that we don't get wastage from the bore? And also, perhaps most importantly, are they not putting down illegal bores so that people can access water without particular approvals? Is all very important and something that probably we haven't focused on or paid much attention to. It is the case that farmers are buying some of their own rigs now to put down bores themselves, but this tends to be more the exception than the rule, at least in Australia. And that's partly because it's fairly difficult work, can take up to 24 hours, 2 days, and a lot of things can break and you can lose very expensive equipment down holes. So what was surprising to us, and this may be difficult for you to read, but what was surprising to us before we started this project on that related project I was talking about is that drillers are particularly important. Hang on. Somewhere. Yep. This one. Were particularly important sources of information to landholders. So we surveyed 4,000 people, farmers, and asked them, where do you get your information from? And the top 4 sources included drillers as one of those sources of information about how regulations apply to on-farm behaviour in relation to water. The other ones were neighbours and peers, family, as you might expect, and also a government website. So drillers seem to be very important in what's going on in agriculture and groundwater, which was another reason for us to look at them. So of course, we've known for a while that we need to regulate drillers, and in Australia, we traditionally did it in a self-regulated model, but back in 1996, when we started paying attention to groundwater, we realised that we probably needed a national system of licensing. It's 20 years later and we still don't have a national system of licensing, although we're moving towards that, and that's partly because of the federal system that we have. So some states think it's a good idea to cooperate and others do not. So in New South Wales, it's one of the holdout states, so it has its own system of licensing, which includes 6 classes. But the basic principle is you get a 3-year license for about $300. You have to reapply, and you have to demonstrate each time that you have the right skills, the right equipment, you've done the right training, the kinds of things you would expect when you're licensing somebody to perform a particular task. The landholder, before they can access a bore, needs to also get a license or a work approval before they put a bore down. And that goes for irrigation bores, but also kind of basic landholder rights like stock and domestic bores. And in practice, it basically works like this. You will ask a driller to come to your property. Before they will drill, they'll have to look at your work approval or your license approval for the particular bore. Then they'll start drilling, and they have to do that in accordance with their license, and they also have to do that in accordance with the approval that you got. So that might be where it's located, so don't do it near telephone poles, for example. And it'll have to be the certain size that they're required to drill for. So often you'll get a monitoring. You might have a monitoring bore all the way up to a full production bore, and it varies depending on the driller. Afterwards, you then have to fill in bunches of papers and give them back to the government so they know where your bore is, what size it is, and those kinds of things so that we know where water is coming from. The trouble is drillers pose a fairly problematic set of challenges for regulators. So the first one is they're highly mobile, well, that can be one of them. They're highly mobile, so they basically put the rig on the back of the truck and drive hundreds of kilometres from different farms at any given particular period of time. So it's hard for the regulator to know where they are. And they're also very remote. So Australia's a big place, and in New South Wales, where this study was conducted, it's about twice the size of California, just a bit bigger than Texas. And so you could be out on a property somewhere, and it's very difficult for people to know that that's where you're located. Drillers also tend to be fairly transient, so they might move between different industries. So you might be in mining, gas, or water at particular times, depending on your skill set and your licensing capacity. And probably most problematic of all, the landholder and the driller might have a mutual interest in colluding. So you probably want to access your water, the driller wants to get paid without going through the administrative costs, and so you might work together and just sink a bore and be done with it. So because of those challenges, we thought we should do this project and find out how effective the current system is going in regulation. As far as we know, it's the first one that's been done on drillers. So we did this through interviews. So we spoke to 26 drillers, 16 government officers, and 3 industry representatives. So to give you an idea on how that maps onto the industry, there's about 300 odd drillers in New South Wales across various license classes, and about 70 regulators responsible for enforcing the laws. Having said that, there's only about 20 that actually go out of the office and look at what's going on in practice. So the large majority of the others are behind their desk, kind of processing applications and things. All right, so let's look at some of the findings. What extent was compliance like in the drilling industry? Certainly when it came to licensing, there was no real unlicensed drillers popping up particularly. So everyone was kind of had their bit of paper and was doing the right thing. There's 2 kind of exceptions or issues with that. One is the people crossing state boundaries, so people from other states were coming down and not getting the right license, which may be problematic if there's different regulatory regimes in place. The second issue was that regulators readily admitted they weren't really out there looking for drillers, mainly for those reasons of mobility and geographic remoteness. It's very hard for them to catch a driller in the act and to check whether they've got the license or not. So there's a caveat in the sense that we don't really know if there's compliance or not, but the general opinion was that most were licensed. Again, there seemed to be compliance with irrigation bores, so most people were only drilling these when they had the right approvals, and the logic to that was that they were large, big, and easy to find, and they would have major impacts, and that we picked up through monitoring bores, for example. So it was unlikely that there was non-compliance there. There were 2 other areas where non-compliance was really popping up. So one was quite small, I guess you could say in inverted commas, and that's procedural non-compliance. So they hated filling out forms, they hated doing the right supervision, and they hated kind of the training process. And you can see there at the bottom a quote from from a government officer that's talking a little bit about basically a driller saying that he was in 3 places at once, 100 kilometres apart, because he wasn't supervising the right drilling rigs, and he got busted for that. So the other main area, and probably the most worrying area where non-compliance was popping up, is in relation to stock and domestic bores, right? So that's basically what you're using for your household and for your stock, as the name suggests. So there's a bunch of statistics here, and I'll just talk you through a little bit because there's a bit of complicated interpretation associated with it. So since 2001, they've picked up 47 stock and domestic bores as being problematic. That doesn't sound like very much, but when you put it in the perspective that between 2011 and 2013, there was only probably somewhere between 8 and 11 officers out there wandering around the state, checking on hundreds of thousands of bores, then it's likely they're probably missing a fair few. And as you can see, there's quite low numbers early on in the period. What happens in 2013 is we get federal government investment in improving compliance and enforcement as part of the evolution of Australia's approach to water law. And so we get a jump in officer numbers, and we see then a smallish jump, but a jump nonetheless in kind of picking up of illegal bores from 2013 up to 2016. Unfortunately, what's going to happen now is the federal money is being taken away, and we're going to lose most of those officers and go back to the small level again. But at the very least, this seemed to be an area where there was some non-compliance happening. And this is just to show you what I explained, which is the green colour here. This blue colour and this orange are the new officers, and they're the ones that are picking up the non-compliance in the bores over time. The response is fairly standard and pretty light touch, so the bottom of kind of the compliance pyramid, so it's more letters telling you that you should do the right thing, the occasional penalty infringement notice, and there's been 2 prosecutions out of a total of 21 where they were fined about $9,000 each, the drillers and the landholder, and some good behaviour bonds, but mostly fairly minor responses. The issue with the stock and domestic bores, based on the interview data, was that they think it's going to be a likely ongoing future problem and a future risk, which is basically death by 1,000 cuts. So many thousands of small bores around that no one's really regulating, and that's partly because they don't have to be metered, and you can take water from them as you see fit. The reasons there's non-compliance in this particular area is a pretty straightforward one to start with. One is the drillers just want the money, so there's an economic incentive for them to drill without getting the right approval or license. The second reason was, and this was a very common one, drillers would be hundreds of kilometers away from their base on a contract. They would be putting a bore down, and the neighbor would lean over the fence and say, "I also want a bore, please put one down." And the driller doesn't want to have to drive back hundreds of kilometers and wait the various number of weeks to get the approval, so they will sink it. And that seemed to be a significant risk. Third reason was drillers were very adverse to filling out the forms and paperwork and the delays, and so consequently they again would be more inclined to put one down. And the fourth was they found the process of interstate licensing very confusing and irritating, because you got a driver's license, you can drive across the whole country, why do you need to get multiple approvals? Probably a more concerning element of the process was a general perception among landholders and drillers that the stock and domestic right was such that it didn't matter if you were non-compliant. So because you have a right to take water, there was a general opinion that translated to you have a right not to get an approval to access that water. And that's technically not true. You need to have that approval. And so there was a general view that what drillers would do was sink the bore down and then apply for the approval afterwards, and do it in relatively good faith, knowing that the department was likely to approve it because you do have that right to access the water. And that creates a bit of a problem, because there's kind of a view that non-compliance is acceptable. And to some extent, the department may have encouraged some of that in the past by giving retrospective approvals. So all up, what do we take away from this, and maybe what are kind of the broader lessons for other places? So I think in water, it would be true to say that inspectoral powers and government powers to enforce things are relatively limited, and that's true of Australia as it is many other places. And this has to be balanced against kind of the difficulties of drillers with their isolation and their high level of mobility. There's general economic pressures and neighbourhood pressures, neighbour pressures on putting bores down, and the general feeling you have a right to access the water, so non-compliance is acceptable. And although we've seen an increase in the identification of these bores, this is likely to drop off. And so the question, I guess, is what do? We could invest a lot of resources to improve the enforcement and compliance system, but that's highly unlikely in Australia and most likely other places. And so the argument that we kind of make is we need to be looking, again, for a mixture of going a little bit back to the self-regulation, but a much more regulatory flexibility approach where we pursue accreditation. So you'd say the best drillers in this industry, we're going to give you the ability to maybe approve a number of the bores or just to hand in approvals afterwards, don't seek them. But to do that, you have to meet a number of conditions. You have to put a GPS on your drill rig so we know where you are. You have to attend certain training courses at certain periods of time. And there may be particular codes or guidelines that you have to follow that you would be informed about, and you would have responsibility communicating those to the landholder. And for those who weren't accredited or didn't meet kind of the best practice standards, you would be subject to much stricter regulatory supervision, hopefully by the resources saved by not looking at the ones that were best practice. And that's it.
Thank you. Very interesting to hear what's going on with the drillers in Australia. So I'm curious, what kind of training courses do you have in mind, or do you give or propose for drillers?
So I just speak loudly. So there's two sorts of training aspects for drillers. So there's one done by the industry, which they need to do in order to get the tick for their license, and then the regulator also has particular sorts of training. And that's the regulators is all about what are the license conditions, what are the rules, and the other side is like screening gravel packs and various things about what you're allowed to do in areas. There is a problem that I didn't speak about in the training, which is a lot of it is done online, and there was a general opinion that a lot of the older drillers were just sitting the courses for the younger guys and just letting them get approved.
Other questions? I had one. So on one of your slides, you mentioned groundwater contamination, I believe, is one of the problems. So one of the things that we see in the States, and I'm assuming you see it in Australia, is some of these wells are constructed with such long screened intervals and even longer gravel packs that they can act as vertical conduits when there are head gradients or head differentials in the vertical dimension. Any comments on that in terms of what you've seen in Australia?
I think you're spot on. I mean, and that is a problem. And so the licensing tiers are meant to address that, to make sure that only the best drillers and the most qualified ones are pursuing those longer ones. We don't have the same subsidence issues that you guys have with the really, really long, deep ones. But that's all I can say in response to that.
I could probably just talk to you,
Yeah.
but I was in Australia too as a geologist, and I remember at South Australia, it seemed like our permit was, we could only go through 1 or 2 water-bearing zones too. Is that true?
Yes.
They're still, so I thought that was really good because they made you define, and I don't know if that's recent, a recent change, but I thought that was a good step in the right direction.
Yeah, and you're right. So there'll be limits on how far you can go and all of that. That's right.